High courts, constitution, appointment and jurisdiction. High courts are an important part of the Indian judicial system. They work at the state level and play a key role in protecting the constitution, fundamental rights, and the rule of law. High courts act as a link between the Supreme Court and the subordinate courts. Their powers, structure, appointment of judges, and jurisdiction are clearly laid down in the Constitution of India. A detailed study of high courts helps us understand how justice is delivered at the state level in India. Constitutional position of high courts. The constitutional position of high courts is clearly defined under Part 6, Articles 214 to 231, of the Constitution of India. According to Article 214, there shall be a high court for each state. However, Parliament may establish a common high court for two or more states or for a state and a union territory. This shows that high courts are constitutional courts and not created by ordinary laws. For example, Punjab and Haryana share a common high court. At present, India has several high courts, each exercising authority over a particular territorial area. High courts hold an independent and important position in the Indian judicial system. They are not subordinate to state governments. High courts act as the highest judicial authority at the state level. This independence is necessary to ensure fair justice and to prevent misuse of power by the executive or legislature. The Constitution also declares high courts as courts of record under Article 215. Their decisions are binding on all subordinate courts and tribunals within their territorial jurisdiction. High courts' judgments and records have legal authority and they have the power to punish for contempt of court. Through writ jurisdiction under Article 226, high courts protect fundamental rights and other legal rights of citizens. Thus, the Constitution places high courts in a strong position to uphold the rule of law and safeguard democracy in India. Composition of a high court. The composition of a high court is provided under Article 216 of the Constitution of India. Each high court consists of a chief justice and such other judges as the President may appoint from time to time. The number of judges in a high court is not fixed. It depends on the workload and population of the state. Some high courts have a large number of judges, while smaller states have fewer judges. Judges of a high court sit either singly or in benches. Important constitutional matters are usually heard by a division bench consisting of two or more judges. This system ensures better interpretation of law and reduces chances of error. The Chief Justice of the High Court is the head of the court and other judges are known as puisne judges. Ordinary matters are usually heard by a single judge, while important constitutional or legal matters are heard by a division bench consisting of two or more judges. This system ensures proper discussion and correct interpretation of law. The appointment of High Court judges is provided under Article 217 of the Constitution of India. According to this article, judges of a High Court are appointed by the President of India. However, the President does not appoint judges on his own decision. He appoints judges after consultation with the Chief Justice of India, the Governor of the concerned state, and the Chief Justice of the concerned High Court. In case of appointment of the Chief Justice of a High Court, the President consults the Chief Justice of India and the Governor of the state. The system of consultation helps maintain the independence of the judiciary and reduces political influence in judicial appointments. The Chief Justice of the High Court recommends names of judges, especially for appointments within the same High Court. This consultative process is meant to ensure that only qualified, experienced, and competent persons are appointed as judges. Judges are selected from experienced advocates and members of the judicial service who meet the constitutional qualifications. Thus, the appointment process of High Court judges aims to uphold fairness, competence, and the rule of law in the judicial system. Qualifications of High Court judges. The qualifications of High Court judges are laid down in Article 217 of the Constitution of India. According to this article, to be appointed as a judge of a High Court, a person must be a citizen of India. This ensures loyalty to the Constitution and the country. Further, The person must possess adequate legal experience. He or she must have held a judicial office in India for at least 10 years, or must have practiced as an advocate of a high court for at least 10 years. These qualifications ensure that judges have sufficient legal knowledge and practical experience. The Constitution does not prescribe any minimum age for appointment as a High Court judge. However, in practice, persons with maturity, integrity, and professional competence are selected. Thus, the qualifications of High Court judges are designed to maintain the quality, efficiency, and independence of the judiciary. Tenure and removal of judges. A judge of a High Court holds office until the age of 62 years. The tenure and removal of High Court judges are provided under Article 217 of the Constitution of India. This fixed retirement age ensures continuity in the judiciary while allowing new judges to be appointed regularly. A judge may also resign from office at any time by writing a resignation letter to the President of India. The removal of a High Court judge is a very strict and difficult process. A judge can be removed only on the grounds of proved misbehavior or incapacity. This process is the same as the removal of a judge of the Supreme Court. Removal cannot be done by the President alone or by the state government. It requires a special procedure in Parliament to protect judicial independence. The removal process starts with a motion in either House of Parliament. The motion must be supported by majority of the total membership of the House and at least 2/3 of the members present and voting. After the motion is passed by both houses, the President issues an order for removal. This strict procedure ensures that judges can work freely without fear of arbitrary removal. Qualifications of High Court judges. The qualifications of High Court judges are laid down in Article 217 of the Constitution of India. According to this article, to be appointed as a judge of a High Court, a person must be a citizen of India. This ensures loyalty to the Constitution and the country. Further, the person must possess adequate legal experience. He or she must have held a judicial office in India for at least 10 years, or must have practiced as an advocate of a High Court for at least 10 years. These qualifications ensure that judges have sufficient legal knowledge and practical experience. The Constitution does not prescribe any minimum age for appointment as a High Court judge. However, in practice, persons with maturity, integrity, and professional competence are selected. Thus, the qualifications of High Court judges are designed to maintain the quality, efficiency, and independence of the judiciary.